Hit and run accidents are unique from other kinds of car accidents because without the identity of the other party, you have to pursue the case against your own insurance company under your uninsured motorist policy. That requires you to take certain steps to inform your insurance company, to inform the police department that an accident has occurred. First of all, when there's a hit and run accident, there has to be contact between your vehicle and the other vehicle. It can't be a near miss. That doesn't count. There has to be actual contact. Now this can be a part of the other car or truck could come off and hit your car, and this would count as contact. What you must do though is you must make a police report within a given period of time, and I would do that almost immediately if I could, unless you're in the hospital. If you are, then have a friend or an acquaintance try to make the police report for you. Also, you have to notify your own insurance company promptly, because if you do not do these things, then you will not qualify for coverage potentially under your own insurance company. So the recovery will be for your injuries just the same as another third-party case against a car where you have the identity, but the money will be paid by your own insurance company. If you do not have uninsured motorist coverage, you cannot collect anything, no matter how badly your injuries are. So make sure that you do get uninsured motorist coverage when you do get your policy. It only costs a couple more dollars a month, and it will protect you if you do not know the identity of the person that hits you. As far as making the claim, it's just the same. You come to the attorney, he advises you, such as coming to my office. We advise the client to give a statement to their insurance company if they have not done so, to give them the full facts, to make the police report if they haven't made the police report. And then they would go and they would get treatment from a doctor just as any other accident. Depending how severe the injury is would depend on what kind of treatment they get and what kind of doctor they would need to see. As far as settling an uninsured motorist case, it is just like settling a case against another insurance company, but we would be dealing with your own insurance company. And in fact, these cases are often much better as far as the leverage you have against the insurance company, because your own insurance company owes you a duty of good faith to deal with you in a fair manner and not to delay in settling your case or evaluating your case. If they do that, then they could open themselves up to being sued for other damages in addition to your own injuries. If we cannot resolve the case, then what we do is we demand arbitration from your insurance company, and usually it's before one single agreed arbitrator, and the arbitration award that is made by that arbitrator would be just the same as a judgment in a court of law. And in fact, it's often economically more feasible to go under arbitration because it doesn't cost as much as doing a full-blown trial, and you can get to arbitration fairly quickly, usually within a year or so of making your demand, whereas in a court trial it could take up to 2 years to get to trial, and they are very, very expensive projects to do. I have arbitrated probably over 500 uninsured motorists and underinsured motorist cases, and we have done very well. I have never lost an uninsured motorist or underinsured motorist arbitration in my career, and we have had some fairly big judgments. I have gotten judgments up to $250,000 in uninsured motorist arbitration cases, and I recently got one where the insurance company had only offered $25,000. We got nearly $100,000 in a shoulder injury case. We are, of course, limited to the policy limits itself, and most people don't have uninsured motorist or underinsured motorist coverage more than $250,000. So unfortunately, that's the difference as far as the economic recovery. When we go to trial against a third party, there is no limit. So if the injury is fairly bad, we can get as much as the jury would award, but in an uninsured motorist case, we can only get up to the policy limits. So that is a limitation that is some detriment. But again, these cases have to be processed according to the policy, and the insurance company has to deal with the client in good faith.